So author writes software. The moment the software is fixed in a tangible medium, copyright attaches, others can't use it without further action by author. Author chooses to adopt the general public license to govern what others can do with the software, and you made the intriguing point then that the general public license gives with certain limits, and that's why you point out nobody is really wanting to challenge it all that much, because it'd be a Pyrrhic challenge. If you win and the license evaporates, then it rubber bands back to the author. That seems so persuasive, it almost proves too much, doesn't it? Because suppose another author writes software, or now with the author, and chooses to license it under the Grand Old Party public license, by which only Republicans may make derivative works and other what would otherwise be copyright infringing uses of the software. One, do you think such a license should be enforced by the courts? And two, couldn't you say the same logic would apply, that nobody would dare to challenge it because half a loaf is better than none, at least let the Republicans use the software?
So fundamentally, I think the question that you asked is, has the law of copyright misuse evaporated entirely? And I think the answer, notwithstanding the Supreme Court's current deference to whatever Congress chooses to say, is no. I think there's still a common law of going too far out there. And as a lawyer who works on behalf of people who are fairly militant on behalf of sharing, I hear proposals all the time about stuff that they think it would be really neat to do that I don't think the copyright law, unalloyed by further contractualization, will permit them to do. I think the actual tool set of Berne-harmonized copyright law has certain limits on the power of the licensor. And I believe that those limits are capacious enough to allow us to create the kind of self-healing commons we have created. But I'm not sure that they would be strong enough to permit the importation of lots of additional contractualizing restrictions as though they were part of the body of copyright law itself. Moreover, I'm pretty sure that if you tried to do it and succeeded in one jurisdiction, you would find that the Berne Convention didn't actually export all of those propositions around the world for you, and that therefore you would have difficulty erecting a worldwide empire around the GOP public license. But I think you're correct to say another thing, which is that if there were a number of self-defending commons raised on different principles around the world, that would create undesirable deadweight losses, which is why I spend a fair amount of time trying to help people see why the GPL is good and doesn't require to be turned into the XPL and the YPL and the ZPL around the world. In fact, I think in the next few years we're going to have a greater consolidation of licenses, not a greater multiplication of them. But it's a conceptual issue of importance, and it depends upon the belief that copyright law all by itself permits some things and not others, and that you can only fill those gaps with the kind of contract law that we try not to use.
Can you recommend any economists who have studied zero marginal cost economics?
Well, see, now, I sometimes joke with my dear colleague Yochai Benkler at the Yale Law School that Yochai is well positioned now to win the final Nobel Prize in economics. But I fear that that's not quite correct and that people are beginning to flood in. I have a little bit this sort of feeling that sooner or later I'm going to wake up and find out that in Stockholm they've decided to award a prize to guys for teaching economists what we have known for 25 years. Eric von Hippel is doing very important work about that, if you want to take just people living in the neighborhood. We are beginning to get in our business schools a bunch of people who are actually trying to think about these questions because they see billions of dollars being bet, and in the good business school tradition they tend to figure out that what rich businessmen and their investors are thinking about is something they might want to pay attention to. In the pure economics departments, unfortunately, we remain a phenomenon too disquieting to consult just yet. But PhD students, of course, do not always do what their professors do. And my guess is that we are merely a few years away from the beginning of some rocket science on these subjects. It's an enormous, beautiful opportunity for the revision of a field. Even in a discipline like economics, it is only so long that people can be prevented from working on really interesting problems. And the day is coming.
Just a general question on market forces and the free software economy. Even in an ideal world, wouldn't you say that, because of the market forces, and then a group of players become especially successful, then they actually, even though it's an ideal world, they actually become powerful enough and they monopolize on the standards again, and we come back to the same system we have today. So I guess the question is that whether this product type system economy we have, is that just a function of the structure we have, or is it, a result of just market forces?
Well, the structure that we have constitutes what we call market forces. I wouldn't want to take the position that the market was a Newtonian mechanism that existed in the universe independent of human social interaction. Look, what we are doing is trying, through legal institutions directed at the protection of a commons, to prevent that commons from suffering tragedy. Because the content of that commons is capable of renewal and has zero marginal cost, the tragedy we're trying to prevent is not Garrett Hardin's one, which was based upon the inherent exhaustibility of natural resources of certain kinds. But there is no question that the commons that we are making is capable of being appropriated and destroyed in the ways that you suggest. Those of us who believe in the GNU GPL as a particularly valuable license to use believe in that because we think that there are other licenses which too weakly protect the commons and which are more amenable to a form of appropriation that might be ultimately destructive. This is our concern with the freedoms presented, for example, by the BSD license. We are concerned that though the freedoms in the short term seem even greater, that the long-term result is more readily the one that you are pointing at. Market participants who are free to proprietize the content of the commons may succeed in so effectively proprietizing it as to drive the commons out of use altogether, thus, if you like, killing the goose that laid the golden egg in the first place. So to some extent, I would say, avoidance of the tragedy of the commons in our world depends upon the structuring of the commons, institutions alone. As I also pointed out earlier in this conversation, however, commons resources need active management. You, as a lawyer, will either engage in assisting to protect the commons or not protect the commons. This is a form of natural resources law for the 21st century. It is about the recognition that no machine will go of itself, that it will require assistance to achieve its goals precisely in the way that you have in mind. The best national park law on earth won't prevent the poaching of the park if there are not committed people willing to defend it. So you offer a general theory of the possibility of commons destruction, and I agree with you. I say two things. We can design a better commons, and we can work our tails off to keep that commons in being, healthy, strong, and well. That's what I'm up to. That's what I hope you'll be up to as well.
Please join me in thanking Jolt and Professor Eben Moglen.